Hello and welcome. My name is Ilda and I'm a partner in the Immigration Department at Kingsley Napley. Given that from the 1st of January 2021, British citizens travelling into Europe will be deemed as third country nationals, UK law firms who regularly send British lawyers to provide advice to their clients in Europe will first need to check whether work permission is required in advance of their travels. This is because every country in Europe has their own immigration rules. Equally, they should check whether there's any requirement to register with the local law society. To that end, I'm delighted to have with me today Tommy Angermair, a Danish immigration lawyer, alongside my colleague Jessica Clay, a senior associate in our regulatory department. I will first turn to Jessica to talk about the regulatory requirements or considerations that law firms should be considering when sending British lawyers into Denmark from the 1st of January. Jessica, what is the regulatory position for UK solicitors wishing to fly in and fly out of Denmark post the 1st of January 2021?
Thanks, Ilda. Well, in Denmark, UK lawyers will be able to provide services on a temporary basis under their UK professional title, but only in respect of UK or international law.
Thank you. Are there any conditions or restrictions attached to the scope of permitted practice?
There are some restrictions, yes. Only EU and EFTA lawyers may appear in court in Denmark, provided they do so in association with a local lawyer. So it follows from this that on the basis that they are third country nationals, UK lawyers will not be permitted to appear in court in Denmark. However, UK lawyers can represent their clients in arbitration, conciliation, and mediation processes. Finally, but perhaps of less relevance to temporary practice, foreign lawyers are not permitted to market their legal advice activities in Denmark.
Thank you, Jessica. Last question. Will legal protected privilege apply?
Well, according to the Code of Conduct for Danish lawyers, the concept of confidentiality is a necessary part of legal practice and a fundamental right which must be respected. As a result, communication in any form between qualified lawyers and their clients is generally subject to attorney-client privilege. That said, there are no explicit legal provisions in Denmark making communications between third country lawyers and their clients privileged. So in reality, the overall position is not entirely clear.
Thank you, Jessica. I now turn to Tommy. Tommy, thank you very much for joining us. Do you have any top tips for UK law firms that need to send their UK lawyers into Denmark after the transition period ends?
Yeah, certainly there are different things to consider. First of all, right now in this COVID-19 situation, you need to be able to enter Denmark, according to the COVID-19 restrictions. And currently that means that you need a worthy purpose to travel to Denmark, regardless of your citizenship. So that also applies to UK citizens. And for normal business meetings, which a lawyer would participate in, or legal conferences, or consultations or whatever, that will qualify as a worthy purpose. You just need to ensure that you have written documentation for the worthy purpose, which can be an email, it can be an agreement, that doesn't really matter. And then you need a negative test, which is no more than 72 hours old. And there's no requirement for the type of test. So it can be an antibody test, it can be a virus test, that doesn't matter. So that's certainly important right now. If we look beyond COVID-19, of course, you need to consider, since UK citizens will no longer be EU citizens, there will be restrictions in terms of entering and working in Denmark. And, the primary restriction is, will I need a work permit? That's the first question you should ask yourself as a UK lawyer traveling to Denmark. And the key distinction, as it is in other Schengen countries, is whether or not you can travel to Denmark as a business visitor and stay in Denmark for up to 90 days within a 180-day period, or whether you need the work permit. The main criteria from a Danish perspective as well is, will I be engaging in hands behind the back activities? That's what we call them in Denmark, or not? So if it's, I will travel to a meeting and listen to a briefing, do knowledge sharing, receive or give training, that will be considered hands behind the back, and that would allow a UK citizen to travel to Denmark as a solicitor and participate in the meeting. But if there's any specific contribution to the output of the company in Denmark, let's say you are working on a project which is in Denmark, and there's a legal issue on Danish law, and let's say you have a Danish lawyer on the case, and the UK lawyer is in the meeting as well, because they're familiar with the global operations of the client. They need to be involved in the coordination, and it regards to activities in Denmark. Then, theoretically speaking, you will need a work permit. So there's a very fine line. Whereas if you travel to Denmark to talk about a project in the UK, it can be a potential M&A transaction in the UK, then you won't require a work permit. Then it's clearly sufficient to travel to Denmark as a business visitor. And as it stands right now, UK citizens are visa exempt. So when I say a business visitor, it means you can just travel to Denmark with your normal passport. You just need documentation for the purpose of your trip, so you can demonstrate that it falls within the business visitor category. So that's really important, and so that's the absolute key distinction, because as in many other countries, the sanctions are really heavy. If you violate, if you work illegally in Denmark, then the threshold for being banned against traveling to Denmark is actually very low for an organization. Just 2 minor infractions, and then you might lose the opportunity to travel to Denmark as a business visitor for up to 2 years. So it's really important to be very mindful of the distinction. And so of course it's important to make sure that your solicitors understand, whether it can be a business visit or whether a work permit will be required. Typically, as a solicitor, because I've participated in many of these meetings in Denmark with UK lawyers, but also the other way around, and in the US, for example, with US lawyers. And, as long as you understand the distinctions, then you should be fine. But of course, there are gray areas, which can be difficult. But mainly you need to consider, is this in relation to an activity, a project in Denmark, a case in Denmark, or is it outside Denmark? That's also an absolute key question that you should ask yourself. And then obviously, as a company, you should have some guidelines, for the solicitors when they're supposed to travel to Denmark and other Schengen countries. What are the do's and don'ts, so you can reduce the risk of them, misstepping, and also show, any authorities that you've taken, reasonable steps to avoid illegal work in Denmark or other Schengen countries. That's really important. And then obviously you need to make sure there's a low practical thing that the travel documents of the UK solicitors are valid, that your passport is valid beyond 6 months after entering Denmark and so forth. And then that I think that those are the most important things to consider. And then of course plan ahead. It's always a good idea to plan ahead. It makes it safer and better for everybody. So that's advice as well. But as lawyers, we often don't have that luxury, unfortunately.
Thank you, Tommy. That was really, really helpful. I think you've made the distinction quite clear. So press ahead, make sure that you always plan ahead where you can. So more for clarification. So assuming it's just a simple business meeting, you're going to meet with this client, there's no chargeable advice, that would be okay to enter Denmark, in a COVID world or post-COVID world. That would be okay to enter Denmark and stay and do the client meeting with no issue. But assuming there is a work permit required, so in other words, it's more than just a meeting. And I'm assuming if the lawyer is giving chargeable advice, because it's something that they're going to intend to charge the client for, then is that then considered as an actual meeting that requires work permission, or can still be considered as something that could be done whilst seeking entry as a visitor?
No, it's I would say it's an element in the overall assessment. because it is a specific overall assessment every time, in principle. So, but it's not a decisive factor in itself. So the key question is still, are you actively contributing to a project, to an activity going on in Denmark? That's the main question. Whether or not it's chargeable is not in itself decisive. So it may be chargeable, it may not be chargeable, but it mainly depends on the nature of the activity that you are engaging in Denmark.
Okay, thank you. So let's assume then that this particular lawyer will have to travel quite frequently into Denmark to give advice to the clients. Is there a limitation on how much time the lawyer can spend then in Denmark?
Yeah, well, it's according to the general Schengen rules. So, it's up to 90 days within a 180-day period. There's no maximum number of entries. You can travel back and forth as much as you want. But of course, if it's for more than 90 days, then you need to think about a work permit.
Thank you.
And there are
that's
certain
my last
exemptions.
question.
Oh, sorry.
Yeah.
I just thought it was worth mentioning that there are certain exemptions which might be relevant. For example, if you're a board member, you might be a lawyer and a board member. It's not super common, but if you are, you can actually come to Denmark and function in all respects as a board member, even in relation to activities in Denmark for up to 40 days without any work permit. So that goes beyond the scope of the hands behind the back activities according to the general business visitor regime.
Thank you. So Tommy, then my last question then is, if you do need a work permit, then how long would it take? And assuming it's going to take a long time, is there kind of any other steps or advice you would give if a work permit takes too long?
Yeah, well, first of all, actually Denmark is generally very efficient in terms of processing time for work permit applications. So it tends to be, but it entirely depends on the grounds for applying for the work permit. So the most attractive avenue would be to use the so-called fast track scheme. And that's a scheme where you have a local sponsor, which is on a fast track list. And if you're on that list, you can actually bring in third country citizens, including UK citizens after January 1st. You can bring them into Denmark and work right away. They just need to show up, at the Danish authorities. It's called CA, at CA's office in Copenhagen, and give their biometrics, submit their fingerprints, and go through a security check, the SIS, Schengen security check, and then they can start working right away, having submitted the application. So you submit the application while they're at home, you travel to Denmark, you give your fingerprints, you pass the security checks, and then you can go directly to a meeting and be engaged in any activity. But of course, that assumes that you do qualify under the fast track scheme. So you will need a local sponsor, and the local sponsor doesn't have to be an employer. So that can be the client that you're visiting. It can be another business partner. Let's say you're working with a Danish law firm, and that Danish law firm is using you as a subcontractor. And then if that Danish law firm is certified, it's not super common that Danish law firms are certified, but they may be, then you qualify under the fast track scheme. So still there is processing time. You'll get your work permit within a couple of months, but that's immaterial because you can start working right away. One of the limitations worth remembering is that in order to get an individual permit under this fast track scheme, in addition to having a fast track recipient of the work or business partner in Denmark, you need to either have work which is limited to up to 3 months, it needs to be for a short term, or you need to live up to certain salary thresholds, which currently is about 60,000 British pounds per year. And then you need a bank account, it needs to be paid to Denmark. So that's not practical, So realistically speaking, the fast track scheme would only apply for any project lasting up to 3 months, where you need to do productive work beyond the scope of a business visitor, where it's only hands behind the back. So the alternative then would be to get a normal work permit, so to speak, for example, based on something called the positive list, which is a list with special qualifications which are in demand in Denmark. Typically, a lawyer won't qualify, but there could be exceptional cases. But it will be difficult to get an actual work permit. You will need a national sponsor, and as I said, the easiest approach, if you're not fast track certified, the client or business partner in Denmark, that would be normally based on your salary, but then you need a bank account in Denmark, and you need somewhere to stay in order to get, you know, your personal ID number in Denmark. So I guess for foreign lawyers traveling to Denmark, that would normally not be a solution. But of course, if you're seconded to Denmark for 12 months or 2 years, whatever, on a long-term project, then definitely you can make it work. And the processing time for a non-fast track scheme application is normally up to 30 days. But right now it's at least 2 months, because everybody, you know, at CA, the work permit authority in Denmark, are currently working from home. And of course they are under pressure due to the current, you know, COVID-19 situation. So it's more like 2 months now, but it's really attractive. Clearly, if it's for up to 3 months, you need to ask about if there's a fast track certification somewhere, you know, with a client, a business partner. Yeah, that's really helpful if you want to get a work permit quickly. And then you can, as I said, you can fly to Denmark and start working right away, having submitted the application for the work permit, obviously.
Well, that's really good news. We've been doing a couple of these interviews with other colleagues across Europe, and unfortunately other countries in Europe are not as generous as Denmark. We've had colleagues tell us that we have to wait weeks on end to get the work permit before you can actually start work. So that's really good news to know that it's possible to actually start work straight away, provided you're on the fast track scheme. That's really good to know. But assuming that doesn't work and you're not you haven't got a sponsor that is on this scheme, I'm assuming that work permits then take a really long time. So are there any other alternatives?
No, other types of work permits, for them the processing time is up to 2 months right now. Normally it's no more than 30 days, but it's up to 2 months because of the COVID-19 situation. So it's still fairly quickly.
Thank you very much. Thank you. We've now come to the end of this session. I wanted to thank my colleague Jessica and Tommy for their time, and thank you very much to all of you for listening. We hope that you found this session very helpful. Thank you.